problem with redirect examination is that the lawyer needs to make a list of every bad thing that the lawyer heard in the testimony and figure out on the spot whether that's something that needs correction, whether the lawyer knows the answer to the question so that it would be safe to ask about it on redirect. And the lawyer has to do all of this analysis as the opposing lawyer is continuing to do the cross-examination, and while the lawyer is figuring out whether that question needs to be objected to. There's too much that's going on during the cross-examination of your own client to be able to do all of the preparation work that you need to do in order to do an effective redirect examination. If you have to do a redirect examination to fix the damage that your client did, then it means that your client got hurt. The object of effective witness preparation is to minimize the need for redirect examination. That's why the witness should give the best answer to the question the first time the question is asked, whether it's at a deposition or in trial. So when the witness is in deposition, the witness should give the same answer in the deposition that the witness would give at trial, so that there is no conflict between the deposition and the trial. We should be telling our witnesses that they should answer questions in a deposition just as if the jury were in the room, so that the lawyer wouldn't have to prepare testimony on redirect. Obviously, some testimony is going to need to be addressed on redirect, but the goal is to minimize your reliance on redirect and maximize your reliance on the witness to get the witness to give the answer correctly the first time the question is asked. So that requires a very different approach to preparation. So let's start talking about the more enlightened way to prepare witnesses for testimony, how I advocate and what I write about in my book. And so the important thing to know is that the first thing about witness preparation is that it's witness-centric. Your role as the preparing attorney is to get to know the witness. You need to do a preliminary assessment of your witness's testimonial skills. And this really begins the very first time that you meet your client, because all witnesses are different. So in all of your interactions with the client, when you're asking the client about what happened and you're talking about different parts of the case, from the very first moment that you have the client up until the time the deposition is taken, you need to be figuring out, what are the witness's testimonial strengths? Is the witness articulate? Does she pay attention to detail? Does she have a consistent memory? Is she intelligent? Is she credible? Is she trustworthy? Is she likable? Is she knowledgeable? Is she educable about the case and about the legal issues? Is she confident? Does she have the capability of answering questions? Can she speak plainly and explain complex things simply? Can she use words in the way that most people would understand them? And you also have to understand what your client's testimonial weaknesses are. Is she careless in the way that she speaks and in the way that she thinks? Is she imprecise? Is she prone to overstatement? Does she have any annoying mannerisms? Does she have a bad attitude or an oversimplistic view of the case? Does she have a sense of guilt or some sense of vulnerability? This witness assessment is important because it guides you in how much work you have to do and what type of preparation you have to give. So if the witness is genuinely a bad witness, then you might consider preparing the witness with the conventional approach. But if the witness is reasonably intelligent and a fairly good communicator, then I advocate this more enlightened approach.